Hello and welcome to day 2 of the 3rd annual Emerging Scholars Symposium. This is a partnership brought to you specifically by the Roosevelt, Truman, and Eisenhower Presidential Libraries, and more broadly by the National Archives and Records Administration, of which the Presidential Libraries are an important part. The Emerging Scholars Symposium is a program that brings you, the viewer, cutting-edge insight and information from a group of scholars who are new to the world of research, scholarship, and the presentation of their material on a national stage. So we're getting in on the ground floor of some wonderful young scholars, and I'm sure they're going to have some fantastic careers ahead of them. I'm Jeff Urban. I'm with the Roosevelt Presidential Library and Museum. I'll be your host and moderator, and I'm pleased to welcome you and to say thank you for taking the time to joining us today. And I'm sure you're going to want to join in and tune in tomorrow and later on this afternoon as well when we have other scholars. Yesterday we had Linda Herview, and she was talking about her book Forgotten: The Untold Story of D-Day and their Black heroes at home and at war. And so if you missed that, you're going to want to check that out. That was a wonderful presentation. I'm sitting in for my friend and colleague, Joy Murphy, who is the education director at the Eisenhower Presidential Library and Museum. And I am delighted to be bringing you the talented young scholars that you'll be hearing from today and then again tomorrow. Today, we have Christopher J. McNulty, and he has a BA in History from the London School of Economics, an MS in History from the also from the London School of Economics, an MS in History of International Relations. He is a PhD student in World History at Northeastern University, and he is preparing to defend his thesis his dissertation later on this summer in August. So, Christopher, we wish you very good luck for that. And he's here to talk about he has a special interest in the special relationship between the Americans and Britons during World War II and in the post-war period. He has a goal to understanding how this relationship developed at the upper level and also at the lower level, sort of GI to GI. And he has a potential eye on maybe doing some teaching down the line. So, Christopher, welcome. Thank you for being with us. And please tell us about your work.
Great. Thank you so much, Jeff. Well, good morning to everyone in Abilene. Good afternoon to everyone watching from Boston, and good evening to people in London. I feel very privileged to have this opportunity to share some of my work with you today. And I'm very grateful to the folks at the Eisenhower, Roosevelt, and Truman Presidential Libraries for putting on this symposium. So this year's theme is about difficult decisions beyond the battlefield. And I'd like to talk to you today about a decision that I think was more difficult than it might first appear. So my presentation is about the United States of America Visiting Forces Act 1942 and its importance in the context of Anglo-American relations. Now, the Act gave parliamentary approval to an agreement reached between the American and British governments, which was expressed through an exchange of notes between the US ambassador to the UK, John Winant, and the British Foreign Secretary, Anthony Eden, during the summer of 1942. Now, these notes granted exclusive permissions to the visiting American military authorities, the most significant of which was exclusive criminal jurisdiction over all American military personnel based in the United Kingdom. So this meant that if an American soldier robbed a bun from a bakery, he would face an American court-martial or military tribunal rather than be brought before a local British court. In the context of the Second World War, it might seem rather predictable that an isolated Britain would willingly agree to, frankly, any request from their American allies because of the enormous strategic advantages that garrisoning millions of troops would bestow. In other words, it looked like an easy decision. However, if we consider the legal side of the matter, the decision doesn't look quite so simple. It amounted to a kind of extraterritoriality that for centuries had been a form of diplomatic subjugation and exactly the kind of demand that the British made on other nations. Of course, the war brought with it an assumption of temporariness on the part of the British, which mitigated any sense of juridical inferiority. But that inferiority was still keenly felt by British members of Parliament in 1942. What I would like to put to you today is the idea Then in addition to facilitating strategic considerations, the Act was also an expression of amity within the special relationship, which is that often intangible sentiment of fraternity between Americans and Britons. The parliamentary debates on the subject are a strange juxtaposition of, on the one hand, strongly worded, legitimate concerns about the constitutional and practical implications of granting a foreign force its own criminal jurisdiction, and on the other hand, sincere and often gushing and obsequious expressions of kinship and friendliness. My argument that the Visiting Forces Act was a legal vehicle for the specialness of the special relationship rests on three premises. First, that the Visiting Forces Act was a constitutional rupture and indeed represented a significant departure and undermining of the British Constitution. Second, that the MPs who granted parliamentary approval knew and understood this and had a sense of these constitutional implications. And finally, that they proceeded anyway with a special relationship in mind. The Hansard parliamentary records evidence all three of these, as do contemporary writings by legal scholars. This research is based primarily on those parliamentary debates on the bill in August 1942, the reporting on it in British newspapers, and the commentary of legal scholars in the 1940s and 1950s. If we go to the next slide, I'll briefly set out the structure of this presentation. Thank you. So I'd actually like to start at the end and explain what I believe the broader significance of the Visiting Forces Act to be. Why should we care about this? Why does it matter that this law adhered with the specialness of the special relationship? And put simply, the reason we should care about this is that status of forces agreements abound in international law today, and the Visiting Forces Act was a crucial stepping stone in the history of their proliferation. I'll then give a brief history of the jurisprudence of visiting forces, including salient cases and agreements between Britain and the United States for the most part, but also relevant examples from other allied states. I will then get into the parliamentary debates around the bill in August 1942, and set out the objections that members of Parliament raised during its passage, as well as the reasons that they acquiesced, emphasising sentimentality. Finally, I'll go on a bit of a tangent to talk about a murder case and a trial in 1944, which is an example of a time when the Act was waived by American military authorities, but still speaks to the remarkable kinship and sentimental closeness that Americans and Brits felt towards each other. Next slide, please. So to start at the end then, I'm going to explain the lasting significance of the Visiting Forces Act and the debates around it in 1942. Although the members of Parliament that passed the Act believed it would only be temporary, the Visiting Forces Act in some ways still governs the legal status of American troops stationed around the world today. This is because the Visiting Forces Act provided the blueprint for the NATO Status of Forces Agreement 1951, which is itself the model for all bilateral Status of Forces Agreements, or SOFAs, between NATO members today. So the Visiting Forces Act is a kind of legal grandparent. Next slide, please. So a SOFA is simply an agreement entered into by a sending state and a receiving state to establish the legal status of foreign troops. It's different from a visiting forces agreement, which only concerns troops that are visiting for a short period, not ones that are based there long-term or permanently. So American troops stationed in Germany or Honduras or Ghana or Korea are governed by these status of forces agreements. And this is significant because there are a lot of them, and most of them are American. So of 236 SOFAs in effect in 2019, the United States was involved in 98 of them as the sending state, which is more than 3 times as many as the next largest sender of troops to overseas bases, which is the United Nations. So this map on the screen was made by the historian Daniel Imvar to demonstrate what he calls America's pointillist empire. And it shows, although it's quite small, it shows the 800 plus overseas military bases that the United States controls. So these things are everywhere. But the data on them, the data that we have on them isn't that great. Not all of them are public. And the best data set we have was built by the sociologist David Vine for his 2015 book, Base Nation. Legal scholars who have traced the genealogy of legal agreements between sending and receiving states suggest that the Visiting Forces Act was the first agreement that gave the kind of exclusive criminal jurisdiction that the United States still enjoys in many parts of the world today. What those MPs permitted in 1942 in the name of the special relationship is still shaping the legal status of visiting troops. However, While the Visiting Forces Act was the first such agreement, it was not totally without precedent. Next slide, please. I'd like now to get into a brief history of visiting military forces. I'll start by delineating salient cases in the United States that explain American attitudes towards visiting forces in 1942, as well as relevant international agreements from the First World War and with other allies that informed the British approach. Just a quick word on the legal principles involved here. Very simply, the question of who should have juridical discretion over visiting military personnel brings two sort of competing principles into conflict. We have, on one hand, the principle of territorial sovereignty, which is now more commonly called low control, and on the other, the rule of the flag, which is now called high control. These ideas are fairly straightforward. Territorial sovereignty carries the expectation that a state will have total jurisdiction over any offence that violates its own laws on its own territory. And this is unsurprisingly the preference for receiving or host states. They want visiting troops to obey their laws. The rule of the flag, on the other hand, is the idea that wherever a visiting force flies its flag, it assumes jurisdiction over its own agents there. And again, unsurprisingly, this is what sending or visiting states normally push for. They want control and jurisdiction of their own troops wherever they are. And these are not necessarily mutually exclusive, since the rule of the flag can apply to matters of military discipline only and not necessarily criminal activity, but it has been difficult to keep them discrete. Next slide, please. So most scholars chart the first international contest over jurisdiction in the Schooner case, which was heard by the Supreme Court, the US Supreme Court, in 1811, 1812. To cut a long story about property rights short, an American-owned schooner was seized by Napoleonic forces while docked in San Sebastian in Spain in 1810. It was stripped, it was recommissioned, and then it was armed for war. Its former owners were somewhat surprised to see it docked in Pennsylvania the following year, and sued for the local authorities to seize it and return it to them. But the local court found it had no jurisdiction to do so, a decision that the Supreme Court upheld in 1812. The principal opinion, written by Chief Justice John Marshall, pictured here, essentially declared that when a nation's agents enter an allied foreign territory, they should be afforded the dignity of certain immunities. The opinion found that commanders of foreign naval vessels had authority to discipline their sailors and soldiers according to their own military codes within the context of their military duties. Whether or not this authority extended to crimes away from their duties was the subject of debate and wasn't settled in the Schooner case. And there were several subsequent cases after the Civil War that further entrenched this rule of the flag precedent. First was Coleman versus Tennessee in 1878-79, where the state of Tennessee attempted to try a US Army soldier for a murder committed during the Civil War under its own state law, despite the fact that he had already been tried and sentenced by a court-martial. Here, this court cited the Schooner case and found that a foreign army or fleet marching through, sailing over, or stationed in the territory of another state with whom the foreign sovereign to whom they belong is in amity are also, in like manner, exempt from the civil and criminal jurisdiction of that place. After that, we had Dow versus Johnson in 1879-80, where General Dow of the US Army was sued in a Louisiana court for property that he had ordered to be taken from the plantation of the plaintiff Johnson, again during the Civil War. Citing both Schooner and Coleman, Justin Field opined, I'm sorry, this is a longer quotation, as well as observed in the recent case of Coleman versus Tennessee, it is well settled that a foreign army permitted to march through a friendly country or to be stationed in it by authority of its sovereign or government is exempt from its civil and criminal jurisdiction. The law was so stated in the celebrated case of the exchange, the Schooner Exchange. Much more this exemption prevail where a hostile army invades an enemy's country. There would be something singularly absurd in permitting an officer or soldier of an invading army to be tried by his enemy whose country it is invaded. Sorry, that was a long quotation. It's the same principle here, although in this case it was applied to enemy territory rather than allied territory. And there are a series of other cases affirming the authority of military courts, including Tucker versus Alexandrov in 1901 and Hamilton versus McClory in 1905. But the important point here is that American courts set a clear precedent and preference for rule of the flag understandings of territoriality for visiting forces, and that their relation to domestic criminal jurisdiction was vague and debatable. Next slide, please. If we move now from American court cases to international agreements, we can see that there is a long list of them, and I promise I'm not going to go through every single one. But the First World War was the first time that Allied powers had to decide who could claim jurisdiction and where on a large scale. Bilateral agreements with France and Belgium allowed Britain to claim legal privileges in areas close to the front line, while Britain refused to reciprocate these agreements for any Allied troops stationed in the British Isles. The Franco-American Agreement of January 1918 facilitated similar conditions for Americans, with the question of reciprocity, of course, not really being an issue. Rather than being determined by staunch commitments to certain legal principles, which is a claim made by the legal scholar Sergei Lazarev, I think that an argument for practicality is actually the best way to understand these agreements, because the scope of French and Belgian courts to enforce local criminal law during the First World War was very limited. And this was, of course, different to the situation in Britain in the Second World War, where the court system remained largely intact. In the interwar period, the Visiting Forces British Commonwealth Act set up concurrent jurisdiction between British courts and Commonwealth military authorities, which was very much the blueprint for the 1940 Allied Forces Act, which I'll come back to in a second. Meanwhile, bilateral agreements with Iraq and Egypt established complete immunity for British troops visiting those countries, whether in wartime or not. So the pattern emerging from the First World War was very much that the British were happy to demand exclusive criminal jurisdiction for their own forces abroad, but loath to grant it to forces visiting the British Isles. The Allied Forces Act and the Anglo-Czechoslovak Agreement of 1940 both continued this trend, as did the series of bilateral agreements that followed the Visiting Forces Act in 1942, involving both British and American troops, and there are a long list of those at the bottom of that slide. So the Anglo-Americans, as sending states, carved out exclusive criminal jurisdiction for themselves, but as receiving states, they refused to allow allies to take any jurisdiction away from their own courts, except for matters of purely military discipline and administration. So we have seen that from the American perspective, the precedent before 1942 was for rule of the flag understandings of military jurisdiction over visiting forces, with ambiguous applications to criminal jurisdiction. For the British, they claimed both military and criminal jurisdiction for their own troops posted abroad, but did not reciprocate. There was therefore a difficult decision to be made when the Americans were to demand what the British refused to give up. Where limited jurisdiction was extended to visiting militaries, as was the case in 1940, it was certainly not done so with the same conviviality that we were to see in 1942 with the parliamentary debates around the Visiting Forces Act. Next slide, please. So the Visiting Forces Bill was a big deal. As it was going through Parliament, the Times newspaper called it an epoch of jurisdiction. MPs, members of Parliament, published letters in national newspapers expressing various concerns, often in very sensationalist language, yet all the while acknowledging the compatibility of American and British civil and cultural life. So I'm going to set out some of these objections as they were voiced in the debates in the House of Commons, and I will then present the reasons for acquiescing, emphasizing pragmatism and sentimentality. And then I'll share some snippets from some of the speeches from MPs with wonderfully ostentatious names. Next slide, please. So when it was brought before the House of Commons in August 1942, MPs from both benches demonstrated understanding of the gravity of the bill's provisions with an array of legitimate complaints to the Home Secretary Herbert Morrison, whose role it was to defend the bill alongside Attorney General Donald Somervell. In addition to the objections that I've listed here, I'd like to add two more that inflected a lot of the parliamentary speeches. And the first was that the bill was little more than a fait accompli. Anyone familiar with British parliamentary politics will know that MPs take their legislating role very seriously, at least collectively, and they vehemently object to anything they consider to be reducing their role to rubber stamping, which is what the Visiting Forces Bill was seen by many to be, based as it was on the agreement already reached between the US ambassador and the Foreign Secretary earlier in the summer. The second was the threat of extraterritoriality and the tone-deaf complaints from that Britain might be subjected to the same legal coercions that it had inflicted on many parts of the world. As I mentioned earlier, extraterritoriality was seen as a legal mode of diplomatic subjugation or even humiliation. Yankee Zheng, who is a historian of modern China, has written about how the Sino-American Agreement of Visiting Forces in May 1943, which itself was based on this Visiting Forces Act, was akin to a return to the unequal treaties and a resurrection of American extraterritoriality that Congress had ended only a few months earlier in January 1943. So many of the speeches adhered with British exceptionalism, with more than one MP declaring that the British justice system was the best in the world and in no need of augmentation through American jurisdiction. But if we move on to some of the more tangible objections, the first was the question of the source of American law. So it was not clear to many MPs which body of American law GIs would be subject to if they weren't going to be under British jurisdiction. Would American military authorities be enforcing only military law or state laws or federal laws or a combination or some other source of law entirely? There were concerns about differences between state laws, where capital punishment had been abolished in some states but endured in others, and how modes of execution varied across states. And there were also worries that lower order crimes against British citizens might not be a priority for American military courts. The Home Secretary, as well as the Lord Chancellor in the House of Lords, emphasised the common legal heritage of the British and American systems and showed that the American military code carried similar standards to British criminal law. So this objection was cleared up fairly quickly. The second major query concerned what would happen in the event of a crime committed jointly by a uniformed American and a British civilian. Would they be tried in different courts? What oath would a British citizen swear in an American court-martial? Would a Briton be denied British counsel? Would the press be admitted? And again, this was cleared up fairly quickly because the Attorney General assured the House that no British soldier or civilian would appear before an American court. And he highlighted the waiver provision in the Visiting Forces Act, which meant that the governments would discuss in the event that there might be disadvantages to trying offenders in different courts. This was a bit more vague than the question of the source of American law, and the waiver provision was not something that the British government would be able to insist on. And we're going to return to this later with the murder case. The next concern was the awkward position that British police would find themselves in. Would they arrest an American soldier and immediately hand them over to the military police? Would they need to become versed in American criminal law? Would they put themselves in harm's way to apprehend Americans breaking American laws in Britain? Would Americans caught in flagrante delicto by British police be more likely to resist arrest, knowing that they were not under British jurisdiction? And these were very legitimate, practical questions to which there were no easy answers. And indeed, the Home Secretary and Attorney General offered none. Wartime policing was tricky enough, and the Visiting Forces Act made it even more difficult. In terms of the Constitution, the most serious concern was about British citizens falling victim to American crimes, but not seeing justice done in British courts. And many MPs saw this as the critical constitutional departure. MP Abraham Lyons proclaimed, "It is a matter of constitutional pride with us that when a man is tried on a criminal charge in this country, no matter how high or how humble he is, or what his rank or nationality, he gets the same invariable standard of British justice." The Visiting Forces Bill clearly threatened this dearly held constitutional principle. And again, there was no real answer to this. It's not an understatement to say that the Visiting Forces Act represented a constitutional rupture for Britain. And this was the great tension at the heart of the parliamentary debates. There was no getting around the fact that the British courts would be giving up total criminal jurisdiction, and that the British Constitution was to be supplemented by the American Articles of War. The only mitigations were the assumption of temporariness that we mentioned earlier, the urgency of war, and the fact that it was the Americans that were asking for it and not some other ally, because when those allies asked, they were denied. Next slide, please. So despite this long list of objections, there were also good reasons to acquiesce to the American request. The first two on this list were put forward in the bill's defence and were wholly unconvincing to the MPs present. The first was precedent, which was something that the Attorney General put forward in the bill's defence. And he tentatively invoked a degree of hypocrisy, citing the claims that the British had made in the French during the First World War, which I mentioned earlier. But MPs scoffed at this precedence, one describing it as no precedent at all. They felt no obligation to show any consistency between what they demanded of their allies and what they were willing to give up to their allies. Another defense put forward by the Home Secretary was the idea of a double offense, meaning any crime committed by an American soldier would not only violate criminal law, but also damage the reputation of the American military. By not granting criminal jurisdiction to the Americans, the reputational damage would go unpunished. This was clearly something that the American military cared about, but perhaps unsurprisingly, British members of Parliament didn't and were wholly unimpressed by this argument. A better reason was pragmatism. The sheer number of American troops that would be arriving in Britain throughout 1942 and 1943 meant that it would be easier for American military authorities to contain and administer as much of what we call the friendly invasion as possible. There was also the question of American legal representation in British courts. It would require a new, difficult layer of organization between British police, British criminal courts, American military authorities, and American attorneys that the Home Secretary indicated was an unnecessary complication. There would also be public displays of confrontation between American lawyers and British judges, which, it was well argued, might not best support good feeling among British civilians and GIs. And this speaks to the last point, which was sentimentality. Despite the validity of MPs' concerns, all of their objections were couched in the most convivial and genial language. Whenever a member complained about what the bill meant for the British Constitution, they more often than not also complimented the Americans or reassured the American people that these complaints weren't personal, or reminded the House of the shared culture between Anglo-Americans, often all in the same breath. And I'd like now to share a few quotations from these speeches. I promise they're not too long, in part to evidence these points and to show this double-sided complaint-compliment dynamic that was going on, but also to share some of the fantastic names that British MPs had in the 1940s. If we could go to the next slide, please. So first we have Tufton Beamish, who said that there are a few things which are troubling me about this astonishing and unique bill, but anything I say is in no sense to be construed as being contrary to the people of the United States. Next slide, please. Here we have Abraham Lyons, who we just heard from citing serious concerns for the British Constitution, who said, "Not one of us who opposes this bill wishes to minimize in any way our unbounded appreciation of our American friends and allies, nor the warmth of our welcome." Next slide, please. We have Noel Goldie, who was a King's Counsel and a judge, said, "We are doing something which constitutes a most unusual proposal, and one which would never be justified or tolerated except under conditions of war and under conditions of the closest feeling of comradeship and of a common legal tradition which exists between the United States and ourselves." And next slide, please. And finally, we have Geoffrey Hutchinson, a line of whose speech gave me the title for my presentation. He said, the House will readily pass the bill, drastic though its departure is from our constitutional practice, but we shall do it not because we desire to establish a precedent for a future departure of the same sort, but because we desire to pay a special compliment to our allies from the United States of America. There is some irony, I think, in his hope that it wouldn't set any precedent for the future. So MPs were awkwardly flattering, even toady, when debating a piece of legislation that would undermine key tenets of the British Constitution. It is worth remembering the wartime context here, and I'm not suggesting that the special relationship was the most important factor in British authorities acquiescing to American requests for exclusive jurisdiction. However, the special relationship was a way for MPs to make this unprecedented move more palatable, both to themselves and to the British public. And it was the special relationship, not the strategic benefits or the wartime determinants, that MPs themselves spoke about. And the Visiting Force, the Visiting Forces Bill passed quickly through both houses in August and came into effect in November 1942. And by and large, it worked just as intended. American troops went about their soldiering under the American Articles of War and were charged and convicted by American military authorities whenever they committed crimes. Those authorities took over HMP Shepton Mallet in Somerset and built their own execution wing there, where 18 GIs were hanged or shot for various convictions during the war. Home Office files show convictions for more than 50 murders and manslaughters, 22 attempted murders, and over 400 sexual offences. So that exclusive criminal jurisdiction was used quite a bit. Next slide, please. So I'd like to take you on a little bit of a tangent now to discuss one particular case of Anglo-American criminality during the war. There are lots of examples of how the Visiting Forces Act worked in practice, and lots of good scholarship, particularly on how African-American soldiers were disproportionately surveilled, arrested, and prosecuted by military police while in Britain, even as the British welcomed them and British authorities eschewed racial discrimination against African-Americans. And we heard a little bit about this yesterday from Linda Herview's excellent talk. But I'd like to focus on one murder case which, despite being the subject of George Orwell's essay, The Decline of the English Murder, is actually a fascinating story, and one that is quite instructive for understanding how American cultural influence could become manifest in Britain, as well as how Britons saw Americans before the law. If we go to the next slide, please. So the case was the murder of George Heath, who we saw in the previous slide, by Carl Hulton and Elizabeth Jones, who are on this slide, in October 1944. It's called the Cleft Chin murder because British police could not immediately identify Heath and reportedly referred to him as the man with the cleft chin. He was identified shortly after when police recovered his effects, but the name stuck. So Carl Hulton, on the left here, was a paratrooper in the 101st Airborne who went AWOL sometime in the summer of 1944, stealing a US Army truck and driving around the British countryside, refueling at various American bases as he went. He met Elizabeth Jones, here on the right, in a cafe in Hammersmith in West London, actually just up the road from where I'm sat right now. Hulton introduced himself as Lieutenant Ricky Allen of the 101st Airborne and a member of the Chicago Mafia. And Jones, for her part, introduced herself as one Georgina Grayson, a striptease dancer from London. They were actually from Boston, Massachusetts and Neath in Wales, and Hulton was certainly not a member of the mob. Hulton and Jones spent 6 days together and went on a spree of random criminality. They assaulted and robbed several women before determining to steal a taxi. The first one they tried had an American officer sat in the back seat, but they succeeded with George Heath's taxi. They hailed Heath, got in, agreed a fare, and shortly afterwards, Hulton shot him through the chest from the passenger seat. Heath died after about 15 minutes, and Jones went through his pockets looking for anything worth stealing. She ended up with £4, a cigarette lighter, and a pen. They dumped his body at Knoll Green near Staines, where it was discovered the following morning by a firefighter on his way home from a night shift. Hulton and Jones were arrested after driving to Piccadilly the following day, and the American authorities invoked the waiver provision that I mentioned earlier under the Visiting Forces Act. This meant that the pair were tried together in a British court, and the trial was in the public domain, unlike the service courts. This was the first time an American soldier had ever faced a capital charge in Britain. After a 6-day trial, both were convicted of murder and sentenced to death. The judge acknowledged that Hulton had committed the murder, but that Jones knew he was armed and likely to use violence to rob Heath, and was therefore guilty under the principle of common purpose. Now, Jones actually received a reprieve from the Home Secretary and was sentenced instead to a life in prison, although she only served 9 years. The murder is interesting in the context of Anglo-American relations for 2 reasons. The first is that it speaks to the influence of American culture in British life, which is something that I'm interested in more generally. Jones had been a fan of Hollywood gangster films and fancied herself a gun moll, and she told Hulton that she was looking to do something dangerous. A lot of the reporting around the murder was written if the two were Bonnie and Clyde, but in the event they were far less competent. When he was arrested, police reported that Hulton had a loaded .45 in his pocket with the safety catch off and a round in the chamber, which is not how I would choose to drive a taxi in London. But the irony of Hollywood's influence on Jones is that the murder was made into 2 films. The first was made in 1948 and entitled Good Time Girl. And it was a pretty libelous depiction of Jones's adolescence, which was based on the murder, changing some of the key details, but also about general delinquency among young women in Britain during the war. The second film, which this is a still from on the right, was called Chicago Joe and the Showgirl, and it came out in 1990. And I haven't been able to see it, but the reviews I've read describe it as exactly the kind of film noir that inspired Jones to go with Hulton in the first place. And it is actually Emily Lloyd-Jones' character that encourages Kiefer Sutherland's Hulton to commit the murder. The second reason for its salience is that Jones's reprieve was protested quite forcefully by groups who clearly thought that Americans and Britons should be equal in the eyes of the law. One group protested outside HMP Pentonville, where Hulton was hanged, arguing that he should have been reprieved. And another, bigger group argued that Jones shouldn't have escaped the noose and deserved to be hanged, which is all the more remarkable because only 10 women had been hanged in Britain since 1900. It is, of course, impossible to qualify the reasons for these feelings. The protest against Hulton's sentence was likely linked to the movement against capital punishment in Britain at the time, and the anger over Jones's reprieve linked to popular wartime animosity against any lawbreakers. But it is interesting that the protests in each direction stressed equality, Anglo-American equality before the law. Their respective citizenships didn't come into it at all, which is a little surprising considering the vitriolic outcry about the murder. We can see the same sentiment here as that expressed in the quotation that I shared earlier from MP Abraham Lyons about British constitutional pride, no matter rank or nationality, criminals getting the same standard of British justice. And there is no sense here of any corrupting American influence, even though it had been Hulton who killed Heath, and no sense that he should receive a harsher punishment, even though, of course, in the end, he did. Next slide, please. So as I mentioned, the Cleftchin murder is an example of when the American military authorities waived their jurisdiction. But to return to the Visiting Forces Act, these are the main takeaways that I'd like to leave you with. The first is that it was a legal vehicle for the specialness of the special relationship. In addition to the strategic benefits, it was a way for British politicians to express in gushing obsequiousness amity towards their American kin, as well as to encourage friendly relations between British civilians and American GIs. The second takeaway is that it was indeed a constitutional rupture, a significant departure from British constitutional precedents and preference, and a difficult decision that would, I think, only have been made in the context of the special relationship. Even though it might be expected that MPs would pass the bill, it was still a very big deal, evidenced by how MPs professed enthusiasm alongside their legitimate, if hypocritical, reluctance. If anything, MPs should have been more critical of the practical considerations of giving away exclusive criminal jurisdiction, because the legal environment that the Act created actually took a lot of getting used to. Commentators continued to worry about the public perception of immunity for American soldiers that was cultivating in some parts of British society. And there were more than a few teething problems, especially for British police. A supplementary police order was issued in September 1942, intended to help police navigate the Act application, but it was constantly amended and re-amended up until the summer of 1945. Traffic offences and accidents were an immediate problem area, since American drivers had to abide by British traffic laws, which obviously weren't covered by the American military code. There were also lots of cases where American soldiers were witnesses or victims of road accidents, and so they were processed by British police, even though they were supposed to go through the local provost's office. And so in this way, British police actually found themselves accountable, in some respects at least, to the American provosts, who made particular requests on everything from how British police should handle American deserters to how they should file their reports. I hope to continue to uncover more evidence of how the Act worked in practice, but hopefully this conveys just how complicated the process of granting exclusive criminal jurisdiction was and what a difficult decision it turned out to be. The final takeaway is that the Visiting Forces Act and the sentimentality that underwrote it laid the foundation for future international agreements around visiting forces, as well as concretizing the specialness of the special relationship, not only in the Second World War, but also in the post-war period. This difficult decision taken in the shadow of war had lasting consequences around the world. And with that, I will thank you for your attention and turn it back over to Jeff.
Great. Thank you so much, Chris. Those of you that are out there watching virtually, if you have any questions, please put them on in there, and we'll be happy to present them to Chris. So thank you for your presentation, Chris. You know, it was interesting. I had never thought of this kind of a thing before. I mean, you say this is happening in 800 places around the world currently, and you know, you hear about different things, about sending troops and those kinds of things. But I had never heard of a SOFA before. Why do we not hear so much about that? Why is it so new to so many people?
It's a good question, and I suspect I've got a few friends serving in the American military, and I asked them who've been posted overseas, and I said, do you know what a SOFA is? Does this make any sense to you? And absolutely, my friend who's a Marine posted abroad, they are briefed on SOFAs. They are told what laws they are under, and there's actually information on the US Army website if you Google United States SOFAs. I think part of the problem is that, as my presentation probably demonstrated, this stuff is really complicated. A lot of SOFAs aren't in the public domain. A lot of them are published, but some of them aren't. Some of them are published only partially. But the other complicating factor is that this only applies to certain military forces, and the legal status of civilians who were employed by the army, or civilians who are posted in other official but non-military posts, they're covered by different things. So there was a case, I'm not sure if you heard of it, in 2019, where a British teenager called Harry Dunn was hit and killed. He was riding a motorcycle by an American, who coming out of RAF Croydon, and she was driving on the wrong side of the road, and it was very confusing whether or not she could claim diplomatic immunity. She did in the end claim it, even though she wasn't able to, and she was very quickly and quietly flown back to the United States on a United States Air Force aircraft. And that was a very tense diplomatic situation, but it was very confusing whether or not she could claim diplomatic immunity, because the agreement under the family relatives of, she was the wife of a CIA employee, the rules governing the legal status of relatives of CIA agents is secret. We don't know what that is. Those are agreements that have been made in secret and not published. So it was very confusing. So I think the fact that they are complicated and confusing is a big part why people don't know about them.
So diplomatic immunity, that's different than the SOFA, right? Because that's diplomats that are there for an extended period, and this other the SOFA stuff you're talking about is I think you mentioned it's short term, basically.
No, so visiting forces agreements are short term, and status of forces agreements are long term or permanent. So if you are an American posted to Germany to go and work in Ramstein or Vogelweh, you are governed by the American-German status of forces agreement. But you're right that it is different from diplomatic immunity, but it's all a bit cloudy and nebulous and confusing.
What year was the cleft chin incident?
1944, October 1944.
44. So that happened roughly 2 years after the implementation of this SOFA, and that was the only time that it was waived, or was that just like the biggest time it was waived?
It was by far the highest profile instance when it was waived, and that lucky for me as a researcher, means that it was held in the Old Bailey. It was widely reported in the British press and the American press, and so we have great access to it. Military courts martial, obviously, were held behind closed doors, and I think the thinking from the American side was that this will look really bad if Hulton is tried by a military tribunal, Jones is tried by a British court. We reach a different conclusion. So that, and also just that kind of that dearly held constitutional principle of seeing justice done in British courts would have been avoided. So this is definitely the highest profile incidence of it being waived, but I'm sure there are others.
That puts me in mind of the concept of double jeopardy. So what would have happened, or what do you think might have happened, or did this ever happen, that that an American military personnel was tried and convicted or court-martialed, and the British locality wasn't happy about that? Was there any opportunity for them to weigh in, or subject this American military person to a double jeopardy of then being tried outside of that, or was that all handled under the sofa?
No, it's a good question. No, there was no recourse for the British at all, and it was likely they wouldn't know what the outcome was anyway. There were so many Americans in Britain during, well, especially towards the end of 1942 and throughout 1943. It's very unlikely that they would have known what had happened to any particular offender, because when an American GI was arrested by British police, if this is how it went, rather than being arrested by American MPs, they weren't allowed to process them at all. And there was, I mentioned the complications between British police arresting American servicemen and then handing them over immediately to the American military authorities. They initially started to process American GIs as they arrested them, but they were, I mentioned, military provosts making specific requests about how police filed their reports. They weren't happy with the information that the British police were asking the American soldiers to provide. They thought it should be, that's American knowledge. They don't want any information about which units are posted where to get out. So it was they started to process them, and then that stopped fairly quickly.
I see. That makes a lot of sense, because you begin to get that information out there. Now you're tipping your hand as to who's there, what they're doing, what they're capable of in terms of military abilities. We have a question. Were similar SOFA agreements set up as the Allied forces liberated Europe?
So it's a good question. So SOFAs weren't actually a thing until like 1952. So the Visiting Forces Act 1942 was the blueprint, the kind of, I think I said, legal grandparent of SOFAs. But as was the case in Dow versus Johnson, it was kind of ridiculous to expect enemy forces to be tried in the courts of their enemy or according to the laws of their enemy. So occupying forces, that occupied Germany and well, not Eastern Europe, but they were always subject to American laws. And the Visiting Forces Act, I talked about the assumption of temporariness. It wasn't repealed until 1952, when a new law, very not confusingly, also called the Visiting Forces Act 1952, brought the NATO Status of Forces Agreement structure into effect from the previous year. So technically, even though the war was over, the American military authorities still had exclusive criminal jurisdiction in Britain just in Britain until right into the 1950s. It's a good question.
So you say that during World War I, this was not considered by the British, that you guys weren't going to allow us to have this special relationship. But then just a generation later, 25 years later, 20 years later, World War II, you were willing. What changed in that time? Was it just the desperate situation of what was going on with Nazi Germany vis-a-vis England's basically standing alone, or were there further cultural things that shifted in that time frame as well?
It's a very good question. So the question of Anglo-American criminal jurisdiction was actually almost resolved in the First World War, but the negotiations were happening towards the end of 1918 and were actually never resolved. It would have been very interesting to see if, as was the case in the Second World War, the United States were the only British allies that were going to be permitted to conduct their own court system. In terms of what changed, I'm not sure a great deal did change. I think there is this is kind of something that I'm looking at more broadly in my dissertation. But I think that the special relationship, underwent a big change during the Second World War. But in terms of elites, which is the diplomats and members of parliament, politicians, elites had always had pretty close relationships transatlantic, like Anglo-American relationships. I think the Second World War was a turning point because of the sheer number of Americans that were in Britain and that were meeting Britons probably for the first time, and Britons were meeting Americans for the first time. So I think it was more important for those British elites, even if their opinions hadn't really changed much in that generation. It was important for them to kind of demonstrate that amity and affability towards Americans, kind of as an example, because if we're going to host, I think 3 million American troops went through Britain. I think maybe 1.6 million was the most that were ever stationed there during 1944. 1944. Then we need everybody to get along. So I think maybe the circumstances of the war changed, but really there was a lot of Anglo-American, among, like as I say, among elites, amity before the Second World War.
Now you talk about this was being worked on through the Parliament, and when you say MPs, you mean members of Parliament. When you first were using that, I was thinking military police, so I was a little confused, but you cleared that up along the way. So that's what's going on your side of the pond. On our side of the pond, where was this being discussed? Was this being discussed in the State Department? Was it being discussed in the Justice Department? Was it being discussed in the military, in the White House? I mean, who on our side was the ones negotiating this kind of situation with the folks on your side?
So this is a very good question, and one that I'm not too sure of the answer on. It's my next question. It's my next research question. I think it was primarily a military, and as I mentioned, like pragmatism was a real reason to do this, even though practically it was very difficult for British police, and it required a huge amount of cooperation between American military provosts and British police. I think as a military matter, it is easier, and especially easier for the visiting Americans who I think, in lots of ways struggle to adjust to lots of different elements of British life, and there are lots of kind of funny examples of that. But from a military administrative perspective, it was much easier if they were subject to the same laws that they'd always been subject to, and that they signed up to either when they were drafted or when they enlisted. So I think I'm sure the Justice Department and the State Department were involved. But we're actually not sure. As I said, the agreement was based on this exchange of notes between the US ambassador to the UK, John Winant, and the British Foreign Secretary, who was Eden at the time. But we don't have much information on those negotiations.
So you read us several quotes, and it seemed like everybody was going out of their way to bend over backwards to say, look, we need this, but we don't want to be offensive. We're happy to have you guys here because, we need the help. We want the help. We're fighting for the same cause. But at the same time, we do have to have this. But so that seems to be, and correct me if I'm wrong, the sort of the public face of this. But what was the tone and the tenor of discussion going on both benches in the Parliament themselves? Was it as friendly as that, or was it kind of as we say in the States, you hold your nose and take it kind of a thing?
Yeah, another good question. It was kind of hold your nose and bite the bullet, and a lot of these MPs. I mentioned that they wrote letters in national newspapers, and they wrote in very sensationalist language. And some of it was also, MPs were writing these letters to newspapers and then repeated them in the Commons. There was one MP who had a very strange and quite upsetting argument about, well, if my daughter is raped by an American GI, I want him tried in a British court, which was, one of the first things that was brought up and was quickly quashed by the Home Secretary and the Attorney General. So it was very much, hold your nose. It's interesting because at the time, British public opinion, and this is maybe more to do with the urgency of the war rather than the sentimentality, which, as I said, was very much felt by elites. But as I said, Americans and Britons didn't really have much interest in each other, and certainly hadn't really met each other or experienced each other's company. But the public opinion was extremely excited to welcome American soldiers. And there are all these great videos of GIs stepping off the ships in Liverpool and being greeted by American Red Cross workers, giving out donuts and coffee, but also by British military bands, by crowds, cheering them on. That opinion kind of ebbed and flowed throughout the war. I think to an extent, Brits got a little bit tired of the American presence, and there are various reasons for that. But definitely in 1942, the British public was quite happy for MPs to hold their noses. And frankly, most Brits didn't really understand, the British Constitution isn't written down anywhere. Brits generally have a very poor understanding of their constitutional rights. And I think that while there was a perception of immunity that was a bit damaging, it broadly went along the same lines of the ebbs and flows in British public opinion, so the American presence generally.
On our side, in June 1939, Franklin Roosevelt invited the King and Queen of England to the United States, and the idea, again, it speaks to your understanding of, we had the same cultural and historic sort of backgrounds, but we really weren't quite sure of each other and really weren't quite aware of each other. So by inviting the King and Queen of England here to the United States and here to Hyde Park, and the president served them hot dogs, the idea was to sort of break down the royalty to, these guys and gals are just like us, and we need to help them. We need to protect them. In the few minutes we have left, I want to ask you, where are you finding all this information? Are you looking in military records? Are you looking in court records? Are you looking in the records of the United States, of Great Britain? Where's all this information coming from?
So a lot of this research I kind of undertook during the pandemic, and so it's very British heavy. Because the materials I was able to access online were like the parliamentary records, full transcripts of every debate are obviously available online, so that was fairly easy to access. British newspapers and some American newspapers as well, but it is very British Anglo heavy. Again, the next step in the research is to go and read. I'm really interested to find out what was going on at these courts martial, and I think those records are held in College Park. It's mostly it was pretty much all online, and mostly on the British side.
Again, when you mentioned College Park, that's what we call here A2, which is Archives 2 outside of Washington, D.C. We have College Park, Maryland, which is another, very large records holding location. And do you think you'll be able to do that online, or do you think you're going to have to come here to do that, or how does that go?
I'm going to have to go. The problem mainly was that I've just passed my comps exam, so the last kind of 11 months I've had my head in books. Exactly. So now that I'm writing my dissertation prospectus, which I'm defending at the end of the summer before I start to write it, I need to, I'm in London on a research trip. Yesterday was the first day in years for pandemic reasons, but also some other reasons that I've been able to get into an archive. So I definitely plan to make the trip down to DC and to Maryland at some point, hopefully this summer, but we'll see about that.
And do you think, Christopher, this will be a book? Do you think this will come to fruition as not just your dissertation, but an actual book?
I hope so. It would be great. I mean, this work, the kind of legal side of it, is probably going to be the first chapter of my dissertation, and the other chapters are going to look at things like sexual relations between Brits and Americans, the approach to entertainment. So looking at USO shows. Bob Hope famously performed in the UK and was slagging off Winston Churchill, but also ENSA shows, ENSA being the kind of the British equivalent of the USO. Also youth, ideas about the future relationship between Anglo-Americans that was created during the war. And there was a great effort on both the American and British sides to make sure that British and American children knew about each other, knew what life was like on the other side of the pond, and we're going to cultivate long-standing friendships between each other. So I hope that will be that will sum in, the dissertation to book kind of trajectory always changes the project quite a lot, I think.
Sure.
But I would hope that it would be a book one day. Yeah.
That sounds fascinating to step from the legal stuff to the cultural stuff to the sexual stuff to the just getting to know each other kind of thing. Of course, we are very, very thankful that you sent us the Beatles and the Stones. So thank you for that. That certainly helped to seal things. And I want to wish you all the best luck with your. I know you're going to have a very, very busy summer. You're going to have your nose back in the books. Defending and getting ready to defend your dissertation. So we wish you all the best of luck for that. If you ever find yourself in the Hudson Valley, please come to the Roosevelt Presidential Library. I'd be happy to show you around, and I'm sure the same invitation would be extended from our friends at Eisenhower and also at Truman. So good luck with your work over there. Good luck with your work when you get back to this side of the pond. Thank you for sharing this fascinating and really peeling back. You think it's so simple, just send troops over there and there you go. But there's a lot of detail and a lot of, as they say, the devil is in the details that needed to be worked out. So thank you for shedding some light on that with us. So good luck, and we'll see you soon.
Great. Thank you so much for having me.
Oh, absolutely. Absolutely. And we'll see the rest of you maybe later on this afternoon or certainly tomorrow as we discuss some other topics with the Emerging Scholars program here. And we look forward to meeting with you then. Thanks for tuning in.
Thank you.